now we're going to have something that's going to be fairly important to everybody here. How many people own a house here? See hands? How about a farm? How about just some land that you like to spend time on? This is going to be important to you. What these people have to say right now affects every single one of you. We have Eileen here, DeRolf. Did I say that right? From the Ohio Citizens for Property Rights. You're going to enjoy this. You're going to learn from this. Listen, learn, and take it back with you to the people that you're surrounded with, because they need to know this information as well too. Thank you.
Thank you, Barry. I really appreciate that. If you can't hear me, please let me know. Before I start to speak, Russell listening to the ground, I'd like to introduce the three other speakers that are part of this presentation. And we work very hard. We hope this is very informative, but it's going to be very fast-paced, so you're going to have to really, really listen hard. My first speaker is going to be Laurie, and she is going to speak to you about how regional boards usurp local control. Our next speaker will be Jennie, who's going to talk about how these regional boards have used tax dollars to force eminent domain abuse. And then we have Eells, who's going to explain to you on how to make a no trespassing sign into a legal document. And again, more information on these speakers as well as myself is in the program. So I'm just going to start in, and I've got 21 minutes. 10 years ago, I retired from 30 years of teaching science in Westerville City Schools. I was hoping to spend my retirement years showing my horses. That lasted 3 years until, like you, I realized two things. My country was in real trouble, and like hopefully many of you, you realize Agenda 21 is likely the cause. When I went to research the subject more, it became clear that there was no easy way to research the topic, so that's what triggered my creation of my website. If when I am done with this speech today, you need to learn more about Agenda 21, please go there, because we are only going to hit the tip of the iceberg. So, what is Agenda 21, often called Sustainable Development? It recently, by the way, received a new name called the 2030 Agenda. Regardless of what you call it, it is an attempt by several rich and powerful coalitions under the United Nations umbrella to create a one-world governance where unelected bureaucrats will control all the wealth and virtually every behavior of the common citizen. These groups will tell you they are implementing sustainable development policies to save the planet from future wars, from environmental degradation, or in order to eradicate poverty. What they will not tell you is in this brave new world, you will live in little tiny houses or in great tall high-rises with stores on the bottom. That's called mixed use. And you will only be able to travel by bicycle, mass transit, or by walking. By limiting us to only those modes of transportation, we will be severely limited in how far we can travel, because if the train only goes to the edge of town, you're only going to the edge of town. That then leads us into the second goal of Agenda 21, which is to get us into town where they can control us. This effort is called the Wildlands Project. The folks pushing this will rarely call it the Wildlands Project. Instead, they'll likely use terms like wildlife corridors, open space, green space, parkland, etc. The goal is to connect all of these restricted areas to create massive belts of land for the wildlife that extend all the way up into Alaska, all the way down into Mexico. Once this happens, the wildlife will have a greater ability to travel than you will. Again, regardless of what term they use, restricting our mobility and controlling our behavior is the goal. That is why it's important to understand that today, bike paths and mass transit may seem perfectly fine, but in reality, they will eventually be a form of control. You see, if the unelected bureaucrats who will be making these decisions decide not to extend the bike paths or transit lines outside the city, you will be unable to travel beyond the city and into the countryside, which for them is a good thing because you will not be able to interfere with Bambi. It is hard to believe that something this sinister could be happening right under our noses. However, it's easier to understand if you learn how Agenda 21 for many decades has been slowly and steadily implemented. Through the second half of the 20th century, the elites in the United Nations were crafting documents and treaties to position themselves to implement Agenda 21. These early efforts in 1992 led to the introduction of 5 key documents at the United Nations Summit in Rio de Janeiro. These 5 documents were the Convention on Climate Change, the Biodiversity Treaty, the Rio Declaration, the Convention on Forest Principles, and the 5th document was Agenda for the 21st Century, now commonly known as Agenda 21. This 300-page document contains 40 chapters that address virtually every facet of human life and contains great detail as to how the concept of sustainable development should be implemented through every level of society. Agenda 21 is the how-to document for sustainable development. It was at this summit in 1992 that Republican President George H.W. Bush, along with 178 other heads of state, signed agreement to Agenda 21. 1 year later, Democrat, newly elected President Bill Clinton, signed Executive Order 12582, creating the President's Council on Sustainable Development. This council contained 12 cabinet secretaries. 6 of them belonged to the Nature Conservancy, the Sierra Club, the World Resources Institute, or the National Wildlife Federation. These same groups work directly with the United Nations to craft Agenda 21, and now are in key positions in the United States to put Agenda 21 policies into every single federal agency. This means that for every federal agency, the Department of Education, the Department of Homeland Security, the EPA, all of them have for 20-plus years been using your tax dollars to advance the goals of the left, which is to transform America. To make something as complex and far-reaching as Agenda 21 that extends its influence back many decades and forward into the future for an unknown amount of time takes powerful forces and total dedication. This comes primarily from 3 groups: the extreme environmentalists, the socialists and communists, collectively the progressives, and the average citizen who is indoctrinated into believing that what those other 2 groups wish to happen is a good thing. It is necessary to know what the former 2 groups, the extreme environmentalists and the progressives, have in common, because that commonality is the glue that holds them together. The extreme environmentalists believe that man, left to his own devices, will destroy the planet. Their solution forces citizens off the land and into a pack and stack situation in concentrated centers where they can do the least harm to the environment, and conversely, where the government will have the greatest control over the citizens' behavior. The socialists and communists believe that if everyone doesn't own land, then no one should own land or property. Their solution is to have the government own virtually all the property and make it available only as it serves the needs of the collective. The key then for both of these groups hangs on taking control of most of the land in America as well as around the world. This is the glue that holds them together. Both of these groups, who have the total backing of the United Nations and the many, many very powerful non-governmental organizations like the Sierra Club, the Zero Population Growth, etc., wish to destroy your property rights. All of these forces together came up with 2 powerful motivators to get Americans willing to accept, as said by Al Gore, the wrenching transformation of society. These motivators were the redistribution of wealth, social justice, and the threat that humans, bad humans, will destroy the planet. Both groups, the progressives and the environmentalists, knew that if they created enough environmental hysteria, citizens would be willing to give up their constitutional rights in order to save planet Earth. In the 70s and 80s, it was called acid rain. I was a teacher, and I'll admit, guilty, I taught this. Was acid rain and global cooling. Eventually, acid rain just went away, and global cooling became global warming. That is, until it quit warming. Now, in order to cover all bases, the left simply calls it climate change. The one consistent thing through all of these years was that it was critical to pin the cause of these climate crises on human activity. In that way, the far left could convince through indoctrination and outright lies parts of the American population to willingly crawl aboard the environmental train, even if it meant giving up their constitutional rights. The far left also knew how soft-hearted, generous Americans can easily be made to feel guilty for their excellent lifestyles, and once made guilty enough, could be convinced to share that bounty to a greater and greater degree, not just in America, but around the world. The far left wants redistribution of wealth for two reasons. The stinking rich don't deserve the wealth, since they earned it off the backs of the poor. Therefore, the wealth should be taken from the stinking rich and given to the poor. Never mind that just giving folks stuff never benefits the donor nor the recipient. It does earn votes at the ballot box for the left, which is one of the primary goals of the left. Equally important is that the redistribution of wealth makes our country poorer, and for a one-world governance to occur, every country must become equally poor. That means the greatest country in the United States must be made, using a favorite phrase of our current president, unexceptional, or using my phrase, weak. That is why over many decades, our culture, our Christian religion, our free market, our traditional family structure, our education system, our financial system, our political system, our military power, are all being systematically destroyed. Simply put, the goal of Agenda 21 here in America is to raise her to the ground and transform her into just another unexceptional socialist country that can be merged with all the other unexceptional socialist countries to form a one-world government where the citizens are lorded over by the elite and managed by the unelected bureaucrats. In case you haven't pieced it together yet, Agenda 21 is not about protecting the environment, nor is it about helping the disadvantaged. It is a political movement by a small group of individuals designed to take control of the earth's wealth and her people. Whether you are aware of it or not, many of you are currently fighting to stop Agenda 21. That includes those of you who are fighting to protect our Christian conservative values and beliefs, fighting against Common Core, are supporting the military, or fighting to fix our $18 trillion deficit and restore our constitutional republic. You are all fighting against policies that are designed to weaken America in order to prepare her to become just another unexceptional socialist country. I applaud all of your efforts. You do understand the tactics that are being used to undermine all these pillars of our society. What you may not be as familiar with are the many tactics being used to destroy both our property rights and our local representative government. It is the belief of those of us who are part of Ohio Citizens Property Rights, as well as many others, that if we lose our property rights and our representation on a local level, we will lose our nation. You see, without property rights, the citizen is little more than a slave. The citizen has no way to create self-sufficiency for themselves and their family without property. For example, if you cannot own property, you have no collateral. Without collateral, you cannot leverage what you have to create more. In other words, you have nothing on which to build your wealth and ultimately your ability to remain self-sufficient. Further, without individual rights, there is no economic freedom for the nation and in turn, no national prosperity. There are many ways property rights are being infringed. Some are obvious, some not so much. But all of them point back at the federal government. Let me explain 4 ways and provide examples of each. 1. The first way property rights are infringed occurs when the feds, all by their lonesome, create onerous federal regulations. You are all aware the federal government is cranking out, along with their agencies, massive new regulations seemingly on a daily basis. Some of these, like the Endangered Species Act, are familiar even to the low information voter. Recently, the EPA and Army Corps together proposed a new rule defining navigable waters. This new interpretation, as stated in a Wall Street Journal op-ed last December, redefines waters of the United States so broadly it covers virtually every wet spot or occasional wet spot in the country, including ditches, seasonal puddle-like depressions, intermittent streams, ponds, impoundments, prairie potholes, and large buffer areas around the water. If the feds put the Waters of the United States rule into effect, and you have any water feature on your property, Control of your property is up for grabs. Ask our fearless leader, Glenn Newman, how he liked it when in early August of this year, Ohio State University personnel, without his permission, came onto his property to do a water survey of Goose Run, a creek that flows under his building in Marietta. The Endangered Species Act and the Waters of the United States rule are just two of the many examples of how through federal regulations the feds take your land or take control of your land, leaving you with no recourse that does not require massive amounts of energy, time, and legal fees. The second way property rights are infringed occurs when the feds and their friends, the environmentalists, cause property taxes and cost per acre of land to increase. This is triggered by the law of supply and demand. Any policy that reduces the supply of land will of course cause the price of land to increase, making it harder to purchase the property. As the price per acre of land goes up, so do the property taxes, again making it harder to purchase and maintain ownership of the property. A perfect example of a tool that's being used more and more successfully here in Ohio and around the country that will do exactly that is conservation easements. A conservation easement is a restriction placed on a piece of property to reduce usage of natural and man-made resources associated with that piece of ground. This is sometimes called giving up the development rights. The typical limitations on improvements include can't subdivide, no buildings, no roads, no property use changes related to agriculture, no energy generation, no commercial recreation, and only 1 or 2 houses. A conservation easement is either voluntarily sold or donated by the landowner and constitutes a legal agreement that is usually permanent and theoretically protects the land for future generations. The landowner will be expected to pay an annual property inspection fee as well as stewardship fees. If the property owner does not abide by that agreement, the property owner can be sued by the entity in control of the property's development rights. In North Carolina, the owners of Hidden Valley Farm, which had sold their development rights to the Carolina Mountain Land Conservancy, created a riding ring and offered riding lessons. This triggered a 2-year lawsuit against the property owner by the Conservancy. The property owner lost and was forced to pay $37,500 in fine and return the property to the way it was before they attempted the economic activity. This gives you an idea of how restrictive these conservation easements are. There are in Ohio, according to the National Conservation Easement Database, 1,531 conservation easements. Here is a map showing the relative number of easements per county throughout the state. The dark green shows counties in Ohio where there are the greatest number of easements. You will notice that the greatest number of conservation easements exist in the northeastern Ohio. The white shows the county with the fewest easements. As you can see, the majority of these are in the southern tip of Ohio. This next graph shows the conservation easements, at least in Ohio, are a relatively recent tool of gaining control and development of the land. You can see the vast majority of Ohio's easements were created since 2000, and let's see, right about the time Barack Obama came into office that they really started to cook. Some of the entities that purchase conservation easements are land trusts, farm bureaus, soil and water conservation districts, sewer districts, state development of natural resources, county health departments, and townships. It is worth mentioning that most of these entities are made up of unelected boards. Add to this, often part of the entity's revenue stream comes from state and federal tax dollars. Collectively, that means that unelected folks are using your tax dollars to restrict the economic activity on private property. This is for the supposed goal of protecting in perpetuity natural resources, wildlife, farmland, etc. This is not done in a vacuum. These efforts have consequences. When the property owner gives or sells his development rights, the conservation easement land is worth less. That increases the cost per acre as well as the taxes on the unencumbered land. Fewer people can afford to buy unencumbered land or pay the increased property taxes on the unencumbered land. So schools and counties are also victims of conservation easements because they rely heavily on property taxes to operate schools and counties, and so they must raise their property tax rates in order make up for the difference. Perhaps the most egregious aspect of conservation easements is the reality in most cases the land is in a conservation easement is restricted from development forever. Those who are holders of conservation easements today are selling from future generations their ability to provide for themselves, to create their own self-sufficiency. No one can predict the needs of our citizens in 10 years, 100 years, 200 years. Yet we are tying the hands of future generations and preventing them from knowing what they will need and having the opportunity to accomplish those goals. In reality, there already exists large amounts of wildland habitat for the wild creatures. We already meet the needs of Bambi. We do not need to add additional acreage to the public domain. If we do, we will end up driving up the cost of land and taxes, reducing the economic choices for future generations, and drive more of our citizens off the rural land. The third way property rights can be infringed occurs when the feds give regional boards grants to be used to entice the local government to advance the goals of the federal government. We are fortunate to have Laurie here today, who is on the board of NOACA, which is a regional board located in northeastern Ohio. She will explain to you how this occurs.
Thank you. I just want to tell you real quick that I received that position on the board due to my activism in protecting property rights. I got the attention of one of the commissioners in Geauga County, and I'm his alternate on that board. So, the designers of Agenda 21 knew that they would never be able to convince Americans to give up our liberties if it was foisted upon us from the top down. So they determined it would need to be implemented incrementally at the local level. An organization called the International Council on Local Environmental Initiatives, International Council on Local Initiatives, was created to help implement Agenda 21 in local governments across the world, including the United States. The designers of Agenda 21 also knew that Americans currently enjoying rights to own larger pieces of property would be the most reluctant to accept these changes. Therefore, they needed some way for the more cooperative people in cities to make the decisions for the rural communities. According to the group, Democrats Against UN Agenda 21, and yes, there is such a thing, by concentrating power in cities, this group circumvents requirements for ratification of international treaties and gives the illusion of local control. The cities then ally in regional conglomerates which break jurisdictional boundaries and will destroy local control. These regional boards are unelected and not answerable to the citizenry. Conveniently, in the United States, regional organizations already existed by federal mandate in the form of Metropolitan Planning Organizations, or MPOs, which were created as a result of the passage of the Federal Aid Highway Act of 1962. MPOs are funded by our federal gas tax dollars through the transportation bills passed by Congress every couple of years. These bills are constantly morphing to take the money that's supposed to be used to maintain our road and bridge infrastructure and redistributing it to Agenda 21 inspired projects. It's important to note that MPOs are not regional governments. They, on their own, have no power to implement any visions that they may have. The power they do have, however, is the funding of the implementation of projects which further their vision. Therefore, they don't serve as a regional government per se, but they serve as a regional grant maker, dangling the proverbial carrot on a stick in front of the noses of unsuspecting elected officials who don't take the time to investigate the motivation behind these initiatives. MPOs are structured with a board of directors which consists of local elected officials and departmental appointees. The MPO that covers 5 of the Northeast Ohio counties, Lake, Geauga, Cuyahoga, Medina, and Lorraine, is called the Northeast Ohio Area-Wide Coordinating Agency, or NOACA, and it is one of the most powerful in the state. Earlier I mentioned that Agenda 21 relies on these regional organizations to break jurisdictional boundaries and erode local control. That is exactly what's happening in Northeast Ohio with NOACA. Here's the current makeup of the NOACA Board of Directors. Board members are distributed by population according to the most recent census. As you can see, members from Cuyahoga County outnumber the board members from the rest of the counties combined. Since the boards of the MPOs determine funding priorities for the local governments that apply for that funding, Rural communities who are more adverse to Agenda 21 policies are drowned out by the cities. Before I give some specific examples of the federal government's funding carrots and the Agenda 21 projects that result, one more major piece of this regional puzzle is the public-private partnership. Even though MPOs are not governments, they're created by governments and funded with tax dollars, and so are public agencies. Public agencies are restricted by things such as the law and the Constitution, but private non-governmental organizations, or NGOs, have more flexibility, and oftentimes an NGO is created for a specific purpose to help a specific public agency work around legal restrictions. This was going to be hard to read, it's pretty small. Chapter 38 of Agenda 21 actually describes NGOs as important partners in the implementation of Agenda 21. In 2010, NOACA created a public-private partnership with the newly formed Northeast Ohio Sustainable Communities Consortium, or NEOSCC. NEOSCC was established to maintain or to manage the $4.25 million federal grant from President Obama's Partnership for Sustainable Communities in order to develop an Agenda 21-inspired regional sustainability plan for a 12-county Northeast Ohio planning area. They called this planning process Vibrant NEO 2040, and as a result of this planning process, NEOSCC came up with its vision and recommendations for the region. Here are two side-by-side demographic maps of Lake County and the very top portion of neighboring Geauga County. On the left is the current population distribution as created by the free movement of people to live where and in what type of neighborhoods they choose. In this map, green means rural. On the right is NEOSCC's vision for the distribution by the year 2040. In this map, green is conserved land, meaning no human development. Within the mass field of green are small pockets of lighter green, which do represent rural living, but by now the term rural will have been redefined. Just look at the pictures here. These are a couple pages of a document published by the Mid-Ohio Regional Planning Commission, or MORPC, which covers the central Ohio counties, which include Franklin County. MORPC distributed this document to other MPOs, including NOACA. Notice how they have redefined rural living. These will be small pockets of dense developments in the middle of nowhere that the previous map shows as rural communities. And here's NEOSCC's vision for the entire 12-county Northeast Ohio region. Dense residential zones surrounded by a massive amount of conserved land with a few bits of redefined rural and agricultural zones sprinkled in. This year, the 45 members of NOACA's Board of Directors voted to adopt a regional strategic plan with vast inclusions of NEOSCC's recommendations without an explanation of them. It appears they were content voting for it in order to find out what was in it. I was one of the two that voted no. There are many examples I could share with you of the kinds of things being done in Northeast Ohio that you should look into in your own communities. However, I only have time for one. One of the grants offered by NOACA is the Total Livable Communities Initiative, or TLCI. This grant is funded using dollars originally allocated for road and bridge infrastructure maintenance, but redirects those dollars to projects that promote alternative forms of transportation, including but not limited to mass transit, bike lanes, waterways, etc. As indicated in the name, the stated goal of TLCI is to make your community more livable. So what exactly does livable mean? This is the Department of Transportation's website. In orange there is the definition of livability. Luckily, NOACA had provided a link to the United States Department of Transportation website, and it states the definition of livability as being able to take your kids to school, go to work, see a doctor, drop by the grocery or post office, go out to dinner and a movie, and play with your kids at the park, all without having to get in your car. I hope I was able to provide an informative overview of MPOs, their role in the implementation of Agenda 21, and the erosion of local control. I would strongly recommend identifying if your county belongs to an MPO, and if so, attending their meetings so you can see what's coming down the pike, and while you're there, please speak up. I don't know for sure, but I suspect the situation our next speaker is contending with may have been the result of similar efforts in her region. Thank you.
Thank you, Kim. That was just excellent. Drilling down at a time like this really allows us to see how creepy this all is. Now, I would like to take the opportunity now to have Jennie Granato come up, and she's going to talk about her, there aren't even words to describe how horrible her experience has been because of her local government losing control because they took that really, really enticing grant from her local board, or regional board.
The Fifth Amendment of the U.S. Constitution states, "No person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." Ever since the 2005 Kelo case, private property rights have taken a beating. The city of New London, Connecticut condemned several properties under eminent domain, transferring ownership of private property to a private developer. The idea was the land would be redeveloped for economic benefit of the community. The private developer won that case, but the land was left an empty lot because financing fell through. My question is, does construction of a public bike path merit confiscation of private property under eminent domain? I agree. Our case involved the taking of our front yard for what was a non-essential bike path. During the process of discovery, we found Washington Township used those exact words to describe the plan that was to be built, this bike path in Montgomery County. On March 6, 2008, the unelected Miami Valley Regional Planning Commission, aka MPRPC, approved federal funding for a $5 million bike path extension. Originally only 5 feet wide and going through a nearby public park, the plan morphed into a 10-foot wide bicycle road. That would cut through private property. This was sometime in January of 2011, when the MPRPC adopted a complete streets policy that required all new road construction to include sidewalks and bike paths. In August of 2012, a Montgomery County representative came to our house to discuss the project. The proximity of the bike path came up and how it would be located right off our doorstep. I explained my elderly mother was handicapped and we used that front door for her only access in and out of the house. She was unable to walk alone without support of her walker, a wheelchair, or one of us holding on to her. Whenever she had an appointment, we loaded the wheelchair into the back of the car and drove up to the front door to assist her out to the car. On hearing this, the county representative said they wouldn't be able to complete the project. Apparently under the Americans with Disabilities Act, it is unlawful to use federal funds in a project that denies a handicapped person access. Well, we thought that would be the end of it, until we received a letter from the county making an offer for our property that was to be used for the project. We were shocked. The road had already been widened once in 1992. Now they were going to widen it again, adding an island and a 10-foot wide bike path that would eliminate our front yard and Mom's only available access to her home. We wrote the county commissioners begging them to reconsider. The construction limits were less than 5 feet from the front wall of our house. And there was a real fear our house would be destroyed with all the heavy equipment moving around it. An historic building, our house was built before the Civil War, and it rested on hand-hewn beams and limestone. The stones had no mortar between them, and they in turn rested on the ground. Some of the beams in the house still had bark on them. The bike path would run right under Mom's bedroom window, and it would be active all hours of the day and night. If that wasn't enough, the plans changed the drainage in our field. What began as a 15-inch pipe in 1992 became a 6-foot culvert, draining water from across the street into our field. We wondered, why the huge culvert? And why not put the bike path on the other side of the road where there were no buildings and there were public parks already in existence? We later learned the land across the street was owned by a wealthy developer. Our plea to the county to veto that plan fell on deaf ears. I began calling everyone I could think of, the governor, our state representative, Congress, the Farm Bureau, the Army Corps of Engineers. senators, the ombudsman, we got nothing. In hopes of stopping the project, we even hired a lawyer who specialized in protecting historic properties. A founding member of the Washington Township Historical Society took up our cause. She wrote the Columbus Historical Society demanding our home be given a historic designation as it was culturally significant to the community. Although the Columbus Society accepted this individual's testimony in several cases in the past, our house was denied that distinction. Even though Austin Boulevard and the entire development known as Austin Landing carried the name of the man who farmed our land and lived in our house. Prior to that, War of 1812 Brigadier General Edmund Munger owned our land. Even Washington Township zoning regulations state sites of historic, archaeological, or cultural value and their environments should be protected to safeguard the character of the feature, including stone walls, spring houses, barn foundations, and underground fruit cellars. Also, no yard shall be reduced in area, making said area less than the minimum required by zoning. Township regulations also protected trees with a circumference of over 47.1 inches, designating them heritage trees. We lost one such pine tree that was over 100 years old. Yet all this was nothing compared to what happened July 31st, 2013, when Montgomery County workers began removing the mature trees and hedges from our front yard without warning. Mom had a fatal heart attack. After that, our case had a whole new meaning. Neighbors appeared before Washington Township trustees demanding to know how such a project could be approved. A group protested in front of our house. We protested at MVRPC meetings. Some even gave out flyers explaining our plight at the Americana Festival, Ohio's largest 4th of July celebration. One group even did a YouTube video on our behalf. Reporters interviewed us, yet the project continued. Since all of this began, Montgomery County delayed our court date 4 times, knowing that justice delayed is justice denied. So here we are today, one death in the family, thousands of dollars in legal fees, one ruined home, and years later, our case is almost settled. Is this the America we want? One where federal money with strings attached overrides private property rights and destroys lives? Or the America where the individual still matters and has the right to ownership and enjoyment of the fruits of his labor? It's up to us. Thank you.
I don't know that I have words after that. That is just heartbreaking. Thank you, Jennie, for being willing to share that, because that couldn't have been much fun for you.
Oh, no.
All right. The fourth way property rights are infringed occurs when the feds nudge the state to create state legislation that impacts property rights. On January 1st of this year, a new set of septic system regulations was enacted that affect everyone in Ohio who has a septic system of any kind. By the way, that's 2/3 of a million people. This is a brief background. The Environmental Protection Agency has been putting pressure on every state to advance the green agenda. In this case, the pressure has morphed into 126 pages of regulations written by the Ohio Department of Health, who then mandated every county board of health implement these septic regulations in their county starting the 1st of this year. None of these folks bringing you these regulations were elected, and by the way, the elected officials never voted on it either. They could protest it if they felt like showing up to protest it. No one showed up. Does that mean they even read it? But believe me, there was only one, Senator Granato, who protested against these regulations. So you might have a chat with your state reps and senators why they did not show up. So all unelected bureaucrats I'm talking about here, and they will keep your elected officials out of this process I'm going to explain. The health board inspectors need not announce they are coming to your property. If you deny them access, they can call the sheriff on you. If the health board representatives determine that the septic system is not up to code or defective, the homeowner will be required to fix the problem. If the septic system is found to be not reparable, the homeowner will be told by the health department, based on the property soil type, topography, etc., the type of replacement system that must be installed. Septic systems range in price from around $10,000 up to $25,000. If the homeowner is unable or unwilling to replace the system according to the requirements of the health department, the homeowner can be charged with creating a public nuisance and can face civil fines of up to $100 a day and criminal fines of up to $1,000 a day. Since as the saying goes, you can't get blood out of a turnip, if the homeowner doesn't have the money to make the repairs or replace the system, they certainly don't have the money to pay the fines. Does that mean the homeowner will be thrown in jail and the home condemned? We will be finding out. After all of this, there are fees that may be charged. Since it will no doubt take years to get everyone on the septic system, our county says 15 to 20 years, the first homeowners that are inspected will start paying fees years ahead of the later homeowners. I would like to know if this is even legal. Certainly, if the health department has evidence that a septic system is failing, they have some obligation to work with the citizen to fix the problem. But to cast a net so broad that every single citizen with a septic system is pulled into this bureaucratic nightmare is just plain wrong. These regulations are working off of the principle guilty until proven innocent. Further, if unelected bureaucrats can trespass on your property with no evidence of wrongdoing, for your own good, of course, what will these folks try next? Will legislation be created to require inspections of the amount of insulation we have in our homes or the efficiency of our appliances in order to reduce our carbon footprint? With elections just around the corner, if you have folks running for the county prosecuting attorney, I suggest you get them on record as to whether they plan on prosecuting your county citizens over violations to the septic regulations. Perhaps a kicker to all of this was demonstrated in my town of Pataskala. My city council was originally told by my county health department that there are 3,000 septic systems in Pataskala. However, when my council was ready to send out notices, bless their hearts, to all 3,000 residents with septic systems that there were going to be 2 informational meetings on the topic, the county health department was only able to come up with 380 addresses. Which begs the question, how do they know there are 3,000 residents with septic systems, and how are they ever going to go inspect those? In summary, these regulations, and there's a lot more to this, but again, time. In summary, these regulations undermine local control, undercut our privacy rights, assume the citizen is guilty until proven innocent, and make it less likely that citizens will be able to afford to live in the country. Yeah. Today, I hope you learned a lot. I hope you better understand the basics of Agenda 21 and how its implementation is turning our nation into just another unexceptional socialist country. I hope you better understand how private property rights are being infringed in many ways, which force our citizens off the road land and into town where they can be controlled. I hope you better understand how property rights infringements are being directed by the federal government in coordination with their own federal agencies, regional boards, and regional boards, and how representative government on a local level is being replaced by these same unelected boards. By now you are either depressed or angry. I vote for angry. As the saying goes, don't get mad, get even. There are things you can do. 1, go to my website, learn more about Agenda 21. It is necessary to understand Agenda 21 to understand the many crazy things going on today and how they're related. However, unless you already have a strong relationship with an official, do not discuss Agenda 21 with them. By doing so, you risk giving the official an excuse to dismiss you as just another conspiracy nut. Just logically use the information you have on any given issue and explain why what the official is doing just doesn't make sense. 2, go regularly to local government and regional government meetings. Local representative government was meant to be, by the founders, to be the most important level of government. The founders knew that we could easily get to local meetings to keep an eye on and provide guidance to the officials in our community. This is our civic duty. Likewise, it is our civic duty to go to the regional board meetings to try to thwart their efforts to usurp control from our local elected officials. Finding out where your community is in the process of implementing inspections of the septic systems or asking what kinds of grants they have taken or are currently going to take might be a good starting point. Keep abreast of your property rights infringements around the state of Ohio by going to Ohio Citizens for Property Rights website or Facebook page. We hope later this week to be able to post on our site a video of this presentation that is currently being videotaped by our good friend Roy Wagner of KRoseVideo. In addition, we hope to have videos of several septic regulations meetings that are being held in Pataskala. That, if you watch those, you will see we can fight back. You may also wish to join on every other Wednesday night statewide conference calls. If so, please go back to our table right back there and sign up on the mailing list, and we will get back to you and provide you the necessary phone number to join this conference call. While at the table, you may want to pick up one of our brochures. Last but not least, we have just enough time to give you an important tool we hope will keep that slimy elected, sorry, not all slimy, mostly slimy, elected or unelected bureaucrat off your property. And at this time, I would like to welcome up John Eells, who is going to tell you about how to create a no trespassing sign on steroids. Thank you, John.
I'm going to have to scoot down here. Eileen is petite, but doesn't she cast a huge shadow? And did you pick up on her use of the word governance, where we would typically use the word government? Be aware of that. Whenever you hear someone talking about governance, they're probably looking at some kind of a connection with Agenda 21. A minor point, but very important. 2 nights ago, I had Chinese food, and my fortune cookie said, and this is for everyone who stands up here today, many will travel to hear you speak. Are there any attorneys in the audience today? Okay, good, not too many. I'm going to be talking about legal issues, but I'm not an attorney, so have mercy on me. May I have a show of hands of those who purchased no trespassing signs from either the Marietta 912 project or from another Liberty Group in Ohio? Good. Were you aware there's a more important component that goes with the signs, an affidavit that needs to be filed with your county recorder? And if you were aware of this affidavit, how many of you got one and filed it with your recorder? That's what I thought. For those of us who tried, there's been nothing but frustration. We simply had not executed a document that met the criteria for filing in Ohio. I'm happy to say this problem has been resolved. What you are looking at is, to my knowledge, the first successfully filed affidavit in the state of Ohio that makes public declaration of the property owner's posting of property. Since this affidavit was filed last week in Washington County, there's been another filed in Washington, mine, and one in Monroe. We now have a precedent that recorders in all other Ohio counties can comfortably follow. The instrument is called an affidavit of facts relating to title and is simply an attachment to the property deed. As the screen shows, page 1 consists of the affiant's statement that the owner has posted notice on his or her property with signage. The affiant, by the way, is legalese for the property owner. A transcription of the signage is included in the affidavit. The instrument number and volume and page number are both found on your deed as filed with your county recorder and are transferred to the affidavit by you as cross-references. Note the margin at the top of page 1. Future affidavits will have a 3-inch margin at the top of page 1 to meet Ohio Revised Code requirements. Page 2 describes the affiant's intent to notify the public of the facts related to warning and notice of private property. Note in the lower left corner the declaration of who prepared the instrument. The preparer name can only be the affiant, property owner, or an attorney. Page 3, Exhibit A, is the legal description of the property as stated in the deed. The best way to prepare the legal description is to photocopy the deed description and literally paste it onto a sheet of paper labeled Exhibit A and photocopy it again. This way you can avoid errors in transcription. This is a simple document, both to prepare and to file. The final element, apart from the affidavit, is form letters to be copied, signed, and sent to agencies or businesses to whom you give permission to access your property. For example, UPS, postmen, and utilities, among others. The draft of these just became available yesterday, so I couldn't prepare visuals, but I have examples today that you can see at the OCPR table. These letters are necessary because when you file the affidavit, you are stating publicly that no one is allowed access to your property without your written permission. So the letters give specific entities permission to access your property for specific purposes. You can send letters to as many as you like, but usually delivery services, utilities, and postal workers are recipients. What about your friends or relatives? There is a narrow window through which they can slide, as neither you nor they are likely to press the issue of no trespassing. Hostile neighbors may be another matter. Note a change in wording on the signs themselves. The requirement that someone wishing access to your property must provide 20 days notification has been changed to 3 days. I'm sorry, the notification with their reason for wanting access has been changed to 3 days. For those of you who have previously purchased signs for Marietta 912, we have a patch that says 3 days to stick over the old 20-day part so you can use the signs you have. If you purchase signs from other sources, please contact your supplier for a patch. Time to date does not allow me to give you a complete tutorial on the affidavit or for purchasing signs, but I can send you this information. Just contact me at my email address shown. I have cards at our OCPR table and you can see me after the conference. We'll soon have packets that you can individualize, probably available through Marietta 912 and other groups. The bottom line is, why is this affidavit of facts relating to title important to you as property owners? I believe if we have lawless government, we can expect to see the escalation of unlawful or unconstitutional activity, including criminal trespass onto our properties. Traditionally, posting your property has been considered sufficient warning to any trespasser to stay off. But as governments become more overreaching, and ours certainly seem headed in that direction, the postings can often be ignored by their agents. If the trespasser is confronted, they may say they didn't see the signs or that there were no signs up. That excuse no longer works, as the posting is a matter of public record. So we've talked a lot about legal things now. Why would you want to post your property? Many people are uninformed about their property rights and believe they must comply with any government or utility company or law enforcement demands and simply allow unquestioning access to their property. We know and understand our property rights now, and we now can hold accountable those who infringe them. Filing the affidavit and posting your property affirms your legal rights as a property owner. So I ask you again, why would you want to post your property? Maybe you want to go on notice that you are onto the government's game. Maybe you just feel enough is enough and you want to draw a line in the sand.
Now, we scripted this so tight that I am sure without even knowing whether we have time or not, we don't. We have a minute. Okay. I'm going to say that if you have any questions for my other speakers, myself, again, right back there at that table, we'll meet there as much as we can during the day. But what I also want to say is that I'm so very proud of you all. I'm proud of you all for being here, for taking the time out of your day and caring. But I also would really like to thank Kirsten Hill for all the help she's given us to make this speech go off smoothly, for Cheryl Blakely for handling these slides so very professionally, for Carol Vicky and Meta Hahn, who kept us on time. Boy, all right, you would have made 8th grade teachers, and my speakers were phenomenal. So I thank all of you for all you do.
Thank you, Eileen, Kim, Jennie, and John. I know this is probably something that you guys are probably really passionate about and have to be, especially Jennie here with what she had to put up with. Let's make sure that the rest of us don't have to put up with anything like that. We got to stick together. We got to make sure we inform everybody.